Why Virginia matters in 2026. Virginia enters 2026 facing a legislative session that could redefine firearms rights inside the state in a matter of weeks, not through federal action and not through a national crisis, but through state politics and electoral math. For gun owners, that makes this moment more serious. State legislatures move faster than Congress, and they do not need bipartisan support to pass sweeping laws. When political alignment exists, the bills arrive all at once. In 2026, Democrats hold a narrow majority in the Senate, a stronger majority in the House of Delegates, and they have a governor willing to sign aggressive firearms legislation. That combination has not existed in Virginia for years. National gun control groups know it, and they view Virginia as a proving ground. If gun laws can pass here without political backlash, the strategy can be exported to other competitive states. But before diving deep, subscribe to our channel where we focus on what the law actually says and why it matters. This session runs from January 14th to March 16th. 2 months is more than enough time for major policy moves. States like Washington, Illinois, California, and New Jersey have all passed sweeping firearms legislation in a short time. The model is layered. Restrict what citizens can buy, limit where they can carry, expand who can be disarmed, and rely on courts to take years to untangle it. What happens in Virginia in early 2026 will determine not just the state's firearms landscape, but the national playbook moving into the next election cycle. How Virginia arrived here. The 2026 session did not appear out of nowhere. Elections created the opening. Democrats gained a narrow Senate majority and strengthened their position in the House of Delegates. With the governor and attorney general aligned on firearms policy, the path to pass controversial legislation is clearer than it has been in years. Briefly, 3 factors open the door. A unified government willing to legislate on firearms, advocacy groups with pre-written proposals, a political environment shaped by suburban voters. Suburban districts matter here. National gun control organizations have learned that suburban voters respond more to safety-based messaging than constitutional framing. That changes how bills are marketed and how they poll. From the outside, it may look like Virginia is simply mimicking blue states. In reality, the strategy is more calculated. Purple states are test markets. If aggressive firearms laws can pass in Virginia without electoral penalties, the model can spread to states like Pennsylvania, Michigan, and North Carolina. Section 2. The political window inside Richmond. Legislative windows do not last long. The Senate majority could flip in the next cycle. A new governor could shift priorities. That uncertainty creates urgency. Lawmakers and advocacy groups know they may not get a second chance. The legislative calendar adds to the pressure. January 14th, session opens. February, committees consolidate bills. March 16th, session adjourns. These tight windows are not obstacles, they are tools. Fast sessions suppress organized resistance, compress debate, and force opponents to react rather than prepare. 3 strategic advantages emerge. Bills move faster than public awareness. Litigation moves more slowly than enforcement. Compliance begins before courts intervene. This is why state-level gun control has advanced faster than federal policy during the last decade. Legislatures operate on political calendars. Courts operate on judicial calendars. The gap between them is where modern gun control lives. Section 3. Assault weapon bans. The centerpiece of the 2026 proposals is expected to be an assault weapon ban. The term is political, not technical. The target is semi-automatic centerfire rifles with detachable magazines. Lawmakers choose different definitions, but the effect is the same. 3 models are commonly used: make and model bans, external feature bans, operating system bans. The more consequential question is how Virginia treats existing rifles. States have tested several approaches: sales ban with grandfathering, sales and possession ban with registration. Registration models are favored by national advocacy groups because they create data systems and require ongoing compliance. Possession bans generate immediate political blowback, but achieve larger policy wins if they survive the courts. Legally, the unresolved question is whether banning commonly owned rifles is constitutional after the Supreme Court's Bruen decision. Several cases are working through the courts, but the High Court has not yet taken one directly. Until it does, states legislate aggressively and let the judicial system catch up. Section 4. Magazine restrictions. Magazine limits are often paired with rifle bans. 10 rounds is the standard political number, adopted not for technical reasons but for consistency. Once 10 rounds are defined as normal and anything above is excessive, the cultural framing shifts. That matters more than most gun owners realize. States use two primary models: sales ban with grandfathering, sales and possession ban. Possession bans have a greater impact because they criminalize existing magazines and force compliance immediately. Sales bans appear moderate but change nothing for current owners. Cases to watch include Duncan v. Bonta from California, Gators Custom Guns v. Washington. Both challenge 10-round limits under the Bruen standard. If the Supreme Court grants and reverses, magazine bans could collapse nationally. If the court delays, states will continue to legislate. For concealed carriers, magazine limits matter more than rifle bans because defensive handguns often rely on standard magazines that exceed 10 rounds. That reality is rarely discussed publicly, but central to the impact on daily self-defense. Section 5. Sensitive places and carry restrictions. Sensitive place laws do not change what firearms citizens can own. Instead, they restrict where firearms can be carried. After the Supreme Court's Bruen ruling required states to issue permits more fairly, several states shifted from limiting access to limiting geography. A permit is less valuable if it cannot be used in daily environments. Briefly, sensitive place expansions typically target public transportation and major public venues, parks, libraries, and recreation areas, museums, government buildings, and stadiums. The newer proposals extend further into areas such as hospitals, campuses, places of worship, and polling locations. These expansions are strategic. Concealed carriers rely on handguns for daily self-defense, and daily self-defense happens in public spaces. For Virginia, sensitive place legislation matters because it affects movement, not ownership. A permit that cannot be used in transit, in crowded areas, or in public venues becomes a permit in name only, weakening carry rights without banning them outright. Section 6. Red flag expansion. Red flag laws, known in some states as extreme risk protection orders, allow courts to temporarily remove firearms from individuals deemed at risk. Virginia already has a red flag framework, but national advocacy groups often push for expansion rather than adoption. Expansion does not change the concept. It changes who can initiate the order and how easily it can be granted. Briefly, red flag expansions focus on increasing the number of eligible petitioners, reducing evidentiary standards required for orders, extending the duration or renewability of orders. These changes matter because red flag laws operate in civil court, not criminal court, meaning firearm rights can be restricted without the procedural protections attached to criminal conviction. For Virginia gun owners, expanded red flag authority increases the likelihood of disarmament through civil disputes, mental health claims, or family conflicts, creating a pathway to gun removal without criminal adjudication. Section 7. Licensing as civilian disarmament. Licensing presents a more subtle strategy. Instead of banning firearms, the state can require government permission before purchase. Illinois uses this model through its FOID card, which functions as a pre-purchase license. The process changes the right to keep and bear arms from a protected liberty into a controlled privilege. Briefly, licensing frameworks typically require mandatory training or education, government processing and approval, fees or renewal procedures. These requirements slow down purchases, create bureaucratic barriers, and produce scenarios where delays function as de facto denials, especially during periods of political tension or government backlog. If Virginia moves toward licensing, the constitutional status of gun ownership changes. Rights become conditional, and conditioning a right has historically been one of the most effective forms of soft disarmament. Section 8. Prohibited persons and people bans. Gun laws can restrict things, places, or people. People bans are often overlooked because they appear targeted and reasonable. In reality, expanding categories of prohibited persons can disarm large groups without passing a single gun ban. States have experimented with adding misdemeanors, civil orders, and mental health criteria to prohibited lists. Briefly, people bans may involve new misdemeanor disqualifiers, expanded domestic or civil protection orders, mental health or substance-related restrictions. These measures do not require ownership to be illegal. They make the owner ineligible instead. Courts evaluate them differently, and legislatures promote them as safety-based reforms rather than regulatory disarmament. For Virginia, gun bans could become one of the most effective tools for reducing firearm ownership because they operate quietly, rely on civil proceedings, and affect future eligibility eligibility more than current inventories. Section 9. The Court Timeline and SCOTUS Wildcards. Every modern firearms law sits beneath the Supreme Court's Bruen framework, but the court has not yet clarified how that framework applies to assault weapon bans, magazine limits, or sensitive places. Several major cases are pending, and any one of them could reshape the legal landscape nationally. Briefly, the key cases to watch include Duncan v. Bonta on magazine limits, Wolford v. Lopez on sensitive places, Grant and NAGR v. Lamont on rifle bans. Court timelines rarely align with legislative timelines. States legislate in months, courts review in years. That delay allows contested laws to remain in effect during litigation, and compliance begins long before constitutional questions are resolved. For Virginia gun owners, the outcome of these cases will determine whether 2026 reforms become permanent, face partial rollback, or collapse entirely under the Bruen test. Section 10. What happens after March 16, 2026? Once the session ends, the focus shifts from legislation to litigation. Advocacy groups file lawsuits, courts issue injunctions or denials, and the political narrative moves to whether the laws survive judicial review. Meanwhile, gun owners are expected to comply during the legal process. Briefly, the post-session landscape involves implementation and enforcement of new laws, immediate compliance from retailers and carriers, multi-year court challenges working through federal circuits. Virginia becomes a test case. If the laws remain in effect and do not trigger political backlash, other purple states may adopt similar strategies in the next election cycle. The 2026 session is not just about Virginia. It is about proving whether aggressive gun legislation can succeed in a competitive state. If it does, the political and legal consequences will extend far beyond the Commonwealth when the courts take over. Virginia's 2026 session shows how firearms laws can shift quickly at the state level, long before Washington, D.C. takes any action, and long before the Supreme Court weighs in. State legislatures operate on political calendars, not legal ones. When the votes exist, the bills move. When the session ends, the responsibility shifts from lawmakers to lawyers, and the courts take the lead. That process takes time, and time always favors the state, not the citizen. For gun owners, the next few months matter. What passes in Richmond will shape who can carry, what can be owned, where self-defense is legal, and how the state defines eligibility for firearm rights. None of this happens in isolation. Other purple states are. Watching Virginia closely, and advocacy groups are watching the suburban vote as a measure of whether aggressive gun policy carries political risk or political advantage. If the laws survive politically and legally, the strategy will not stay in Virginia. It will move. If the laws trigger backlash or judicial intervention, the strategy will slow. Either way, this session becomes a test case for how modern gun control advances in a post-Bruen country. If you want to stay ahead of these changes, pay attention to legislation, litigation, and how courts apply the Bruen standard as new cases reach the federal circuits and the Supreme Court. For more analysis, breakdowns, and updates as these bills move through Richmond, make sure to subscribe to the channel. Staying informed is part of staying prepared, especially when your rights are shaped by timelines you do not control.